So, good morning. My name is Victoria. For those of you who haven't worked with me or don't know me yet, I am one of the estate planning attorneys with the Copenbarger law firm. One of the big things at Copenbarger is we want to make sure that we're checking in with you and that our clients are checking in with us to make sure that your plan is being kept up to date to ensure that you, your family, and your assets are still being properly protected and will continue to be protected even after you are gone. So when we're talking spring cleaning, there's a few pieces to this. So first and foremost, have you actually set up a trust yet? Have you set up an estate plan yet? That can be even a New Year's resolution that you have, is making sure that as you're moving into this year and into future years, you have these protections established ahead of any emergency or anything happening. The second thing, though, is if you already have a plan, are you keeping it updated? As your life has changed, as the law has changed, have you come in to see us to ensure again that your protections really are still the appropriate ones for you and your situation? So, for those of you who either don't know us or haven't seen us in a while, one of the things I want to make sure you are aware of is that we have added a few new attorneys to our roster. So, we have welcomed a Mark O'Brien and Elaine Alston to our team. Now, Mark works in our estate administration department. So, in addition to doing estate planning, we also have our department that helps walk alongside loved ones, family members, trustees after somebody has passed away. That way, there is an opportunity for them to not only talk with an attorney to make sure everything will be done correctly, but in many cases, actually have us as your attorneys do the work for that person. So it ends up taking a large burden off of people and, frankly, a lot of stress and time consuming tasks off of people by having us involved. Elaine heads our estate litigation department, and as much as everything we talk about is how to avoid court, there are points that court is inevitable. It can be families are fighting, something wasn't done correctly at the time, whatever that may be. The litigation department is there if or when that becomes necessary. And then we also do have still our business and tax department headed by Sunny Boren, who's been with us for quite a while now. But in that department, if you have any questions about rental properties, taxation, about charitable giving, about a business that you have, she is absolutely the person that we would turn to. But of course, we could not do what we do as attorneys without our incredible staff. And so a lot of times our clients are working with not just an attorney, but sometimes two, three, even four of our staff members to make sure that your questions are answered in a timely manner and that we can get everything done for you as quickly as possible. We also have offices all over the state. So if you have moved out of one of our areas, likely we still have an office near you. If you have family who need to see us, we likely have an office close to them. But we can, of course, do plenty of work on Zoom, on the phone, and through electronic means. So if that's ever an issue, just let us know. So let's get you started. And as I mentioned, if you have any questions, please feel free to put them in the chat or the Q&A as we're going through. One of the questions that I just received is, will this presentation be recorded and available to clients online? And the answer is yes. So this is a recorded webinar. All right. So first and foremost, have you actually established protections at this point? So this is a cornerstone then of what needs to happen for the rest of this webinar after that. So first and foremost, again, have you actually put these documents in place? So when we're talking about an estate plan, it's generally not just one document. So in some cases, what we'll see from other people is they'll bring a trust for us to review that was prepared by a different firm or some kind of online company. And they'll bring us just a trust. And the next question I have is, do you also have a will, a power of attorney for finance, and a healthcare directive? And in a lot of cases, the answer is actually no. And the problem with only having one of these documents is you are often then being left unprotected in ways that you don't actually realize. So one of the most important documents to ensure that you have is your healthcare directive. The healthcare directive is there to ensure that if you can no longer make your own medical decisions, somebody else has the authority to do so for you. It is actually very misunderstood that there is literally not one person, not your spouse, your parents, your children, nobody that has implied authority to act for you. So you either have to be able to verbally tell the doctor your spouse can make your decisions, Or if you can no longer verbally tell them, it has to be in writing. Or literally legally, the doctor is unable to tell your spouse what is going on with your care if they have not been given that authority. So this is an extremely important document to make sure that you not only have in place, but that has been kept updated. Because as life does change, who you have as your representatives may also change. The second thing is making sure for your healthcare directive that you had it done since 2004. If your healthcare was done before 2004, unfortunately, it is actually no longer valid. So it needs to be not only done, period, but also current, relevant, and will be accepted. If you haven't started one or you have questions of is yours still up to date and valid, absolutely come and talk to us. Now, the next document that goes hand in hand with that one is your durable or financial power of attorney. The durable power of attorney is used again in the event you can no longer have the capacity to manage finances. So instead of medical, it's now capacity regarding finances. With that, again, you need to make sure that if you can no longer give somebody else authority by going into the bank yourself or adding somebody to an account, that you have in writing who has the authority to manage things for you, sign checks, pay bills, and keep the financial wheels running, even if you no longer can. One thing to note, though, is if you already have this document, it is extremely important to make sure it has been updated in the last 5 years. Banks are really cracking down on financial fraud and elder abuse, which is a good thing. But the consequence has been that if you have a document older than 5 years old, they are in almost all cases at this point not accepting them. And what has essentially happened is it has caused us to either have to fight directly with the bank or even in some cases have to look at court as an option to have the bank actually honor that existing document. It is much easier and frankly much more cost effective to just have this updated. So if you already have one, but it's older than 5 years old, now is the time to come and see us. Now, the other issue with just flat not having these documents or not having valid documents is, again, we have to go to court. So I just mentioned that in some of the cases with the financial power of attorney, we are having to have court involvement. And the reason is that if the documents are not in place or no longer valid, again, nobody has the authority to make those decisions. And so we actually have to go to court to ask them to appoint and approve somebody to manage your medical and manage your finances. And it is extremely time consuming. It is not cost effective. It is very cost prohibitive. And so it is something that, again, if you can avoid, absolutely do it. And it is truly having those two documents in place and having them up to date. Now, the next question that we hear is, okay, do I need a will or do I need a trust? So let me pause really quickly for a question. The question that was received is who should keep the healthcare directive and power of attorney documents, our family or the attorney? So that was question one. This is 100% client by client based. And the reason I say that is depending on who you have and who you want to see the respective documents, that's going to dictate, do you want them to see them now, or would you only want them to have them in the event something happened? Your attorney will always keep a copy, or should, at least at Copenbarger we do, always keep a copy of what you have signed with us. And so if you don't feel comfortable giving it to the person yet, you can always tell them to reach out to us in the event that that happens. The same is for the question two of who keeps the list of assets. We will keep the ones that are provided to us, but generally we recommend you keep a running list. And again, it's then up to you of who gets to see that besides yourself and us as your attorney. All right, so back to, do I need a will or do I need a trust? So you would qualify for a will if you own no real estate, so no pieces of property, no residence, and or you have less than $184,000. If you qualify for those two conditions and those have to both be met, then a will could be adequate enough to protect you. The problem is if you do own a piece of property and or have more than that $184,000, a will is not going to properly protect you. The reason is that the court, again, has said your will did not answer enough questions before you passed away. And as a result, the court now says they need to answer those questions. Those questions that they're looking to answer include: do you owe anybody money? So, house mortgages, if you have a car loan, if you have any outstanding debts, those then need to be paid. Did anybody owe you money? Those things then get paid to the estate. Ultimately, who's in charge of making sure all of this is done and correct? And then last but not least, where does everything transfer and when after you have passed away? So the court has at that point a lot of say, a lot of control, and it is very, very time consuming to say the least. When we're talking about time, unfortunately, the average length of a probate can be anywhere from 2 to 5 years after somebody has passed away, even in the simplest of circumstances. The reason is that everything follows the court's calendar. And so, depending how busy the court is at that period of time, will absolutely then depend on when can you go in for court hearings and when can things ultimately be settled. The other huge issue with probate is it is extremely expensive. Probate costs anywhere from 5 to 7% of the gross estate. What that means is if you own a home that has the gross value of $1 million, so you could sell it for $1 million, the court does not care if your equity was only 100,000. They'll put the percentage on that entire $1 million. So as you can imagine, if you own a house with a mortgage, if you have other outstanding debts, probate just eats into the cost of your estate over and over and over again. So one of the questions that just came in is the person is asking, is the threshold focused in the documents that are needed focused on California, and are they different in other states? So there's two answers. The threshold for probate may be different in other states, but generally the rules follow the same principles. That if you're over that threshold and you don't have a will or a trust, I apologize, if you don't have a trust, you would still wind up in that state's probate court. The other thing is that the documents we create here at Copenbarger are accepted in all other states. There may be state by state modifications that are necessary. So I know Texas has a homestead provision that needs to be added in if you're living in Texas, but the document itself, the heart of it, actually is still accepted and valid. So those pieces at that point can still apply no matter where you currently live. Right. So the good news is that court, again, we'll talk California today, but probate court can be avoided, and that is by using a living trust. So a trust is essentially there to answer all of those questions that the court says a will did not correctly answer or adequately answer. So your trust answers what happens if there's any debts owed or that you owe. How do those get settled? Who ultimately gets to take over and administer things if you can no longer do that? And then you get to also set the terms of who or what is going to inherit and when are they going to inherit. One of the things we'll talk about today is protections for beneficiaries, that not all beneficiaries can or should inherit at the same times or in equal amounts. But those are all things, all protections that you can include in your trust anytime that you think it's necessary. Now, in addition to the benefit of avoiding probate, another big thing is that your trust allows for tax planning. Tax planning is something that applies to all of us, whether we like it or not. It is not just reserved for the uber wealthy. With tax planning, we can be talking property taxes, income taxes, capital gains taxes, gift taxes, inheritance. There's a lot, unfortunately, of taxes that apply to us or our estate or to our beneficiaries. And it is very important then to understand you do have options available. What we are very much here to do is ensure that there is not one penny more than is legally required paid in taxes, either during your life or after you have passed away. And so again, with your trust, you're able to, at a minimum, reduce taxes that aren't legally required. But again, in most cases, actually eliminate those unnecessary taxes. It just means you need to come in and make sure that your plan is doing the job for you. But all of this ultimately is to ensure that the court doesn't have a say and that it is your wishes that are the ones carried out. But there is one caveat to a trust and keeping out of probate, and that is that a trust only protects what it owns. So, what that means is when you set up a trust, the job is not done. As your attorneys, we ensure that your properties are protected in the trust. So, the title on your home will actually now identify the trust rather than just you or you and your spouse as sole individual people. You're now trustees in a trust. It does not change your taxes, it doesn't change what you can or cannot do. It just ensures that when you pass, the court has no say. Other assets that are generally included are your checking accounts, savings accounts, and non-retirement stock accounts. So if you do not know if this was done, if you're just starting off the process and you want to ask more questions about this piece, absolutely come and meet with us. With that being said, we do understand that things happen. When you come to meet with us, we're signing your documents, there is a lot of information being given. And there's a lot of information today and throughout this entire process. And so things can slip through the cracks. You haven't seen us for 10 years. Things have happened. You've opened new accounts. You forgot to put them in the trust, and you ultimately then pass away. What that would ordinarily mean is that the court still has access to those assets to determine what happens to them. But we have created what is called a pour over will that serves as a safety net and tells the court, no, you don't get to touch that asset. You need to give it back to my trust. So that goes all the way back to the very beginning where I said, when people bring us just a trust and they don't have all of these other documents, it is a problem. Because if life does not go perfectly and the rules are not followed precisely, it can have catastrophic consequences. And so you need an attorney who is putting all of these different protections in place to help prevent any of those disasters from occurring. So, for the assets that a trust would include, it is non-retirement stock accounts. So your IRAs, your 401ks, most annuities, life insurance, those are things that generally speaking do not go in the name of the trust as an owner. Your regular brokerage stock accounts would at that point, again, in most cases, go into the trust directly. That again, though, is something that if you have any more questions on your situation specifically, come and talk to us. We would much rather it be done correctly up front than it not be done correctly and have a potential issue down the line. Now, a lot of what I just talked about is focused on the assets that have a true monetary value. It's an easy value to figure out in one way, shape, or form. But there's another part that really does impact, especially what happens after you are gone, and that is your stuff. Stuff, unfortunately, can lead to some of the largest fights and most expensive fights that we see. Because what we hear all the time is, well, my kids don't want anything, they say get rid of it, which is generally very true right up until the point you are gone. And then all of a sudden, your stuff becomes you, the emotional attachments, the memories. Sometimes, I mean, literally, it can be the shirt that you wore that smells like you. Those things all of a sudden embody mom, dad, grandma, grandpa, whoever it might be, and can lead to, again, some very emotionally charged fights. So, one of the things that we have done in our Copenbarger trust, and so it has to be a provision in the trust you have that allows this, but it says if you have an item that you want to designate to somebody specifically, you can do so simply by writing out a separate letter that is signed and dated by you. You don't then have to pay us, frankly, to update your trust. You can do as many of these as you want. You can destroy them at any time if things change, but it allows, especially if you think somebody would be emotionally attached to something, or there's family history that you want to make sure is passed on, this is then something that you can do to help prevent some of those fights after the fact. Really quickly, another asset question is, should long-term care, I assume long-term care insurance, be put into the trust assets? Generally, the insurance can be identified, but it's not actually owned by the trust. It would still be on the person, not the trust itself. So in most cases, the insurance in long-term care plans don't need to be changed at all. So again, if you have any questions on your assets, both the finance piece or the emotional side of things, come and talk to us. It again is much easier for us to answer the questions ahead of time than, especially if you've already passed away, try to help the family figure it out after the fact. Everything we emphasize is pre-planning. Anything you can do before the disaster strikes or before the event happens, it puts you and the family in a much stronger and more protected position than if we're trying to play catch up or clean something up after the fact. So now let me transition. For those of you who do already have a trust, what has life done that may impact that trust? So your estate plan is on a life cycle, and that life cycle is yours. By that, I mean things change. When you first came to see us, were you married? Were you single? Did you have children? How old were they? Have you gotten divorced? What has happened that may or may not impact your plan? That is a huge question that absolutely needs to be answered and looked at. And we recommend for our clients that they come in and see us every 3 to 5 years. The reason for that is to ensure that we catch what has happened in that period of time, to ensure, again, we have caught it before anything has ever happened. So let me pause just one more second. For the letters of instruction, yes, they need to be signed and dated. Correct. All right. So back to life planning. So what has changed in your life that may impact your estate plan? Well, as I mentioned, did you have children and how old were they? So a huge period of time that we see changes in an estate plan is you had minor children and now those children are adults. And there is actually a lot of changes that can be needed at that period of time. When your kids are minors, you're focused really on, God forbid something happens before they're adults, legal adults, who is going to take care of them and who would protect their inheritance and use it on their behalf. Now that they're adults, are they the ones who should be making decisions for you? How will they inherit? Are they married? Are there protections that are needed for their inheritance? What is going on now that they're adults that has shifted to where either they should be more involved or in some cases still should not be? Are the beneficiaries you had still the same? So this is really important if you, for example, did not have kids and now do. I've met with a few people over the years where when they first came to see us, they either only had one child, they had no children, and it's now been a sizable amount of time. I actually just met with one where they had two kids identified in their trust, been about 10 years, and in that time they had had three more children. Those children were not identified in the trust. Now, at Copenbarger, we plan for that sort of thing, so it still would have been okay. However, it is still very important to make sure that those children are named, especially if you, for some reason, did not want them all to inherit equally, or in some cases, want them to inherit at all. So again, it's important to make sure that you come to see us as your life is shifting. Have you moved? Have you moved into California, or are you planning to move out of California? Especially if you're moving here or have moved here, we want to make sure that your documents are California compliant. If you're moving out of state, in most cases, we reassure you that everything will be completely fine. But there are certain cases where we say it is important to ensure you talk with an attorney in that state, like Texas, to have these certain rules included that we are not able to do. So if you're planning to move, this is something also to make sure that you talk to us about. So, especially if you are somebody who has been married or divorced, this is a huge period of time to make sure that your estate plan gets updated. This has a myriad of different reasons. For one, if you have since gotten married, so you started as a single person, it was a trust just for you, and now you are married. There's a lot of tax protection you can do now as a married person that you actually could not do as a single person. So that is something to very much come and talk to us about. How has your estate grown now that there's two of you? And is there additional tax protection that is needed? The other thing is this your first marriage? So with blended families, there can be concern of, if I pass away before my spouse, do I want them to be able to change my half of the planning? Would I want there to be any concern that they could change the entire trust and then at some point even remove my children if that became an issue? Most people say, I don't want to run that risk. And so, again, there's more protections that we can then put in place. The other thing is, if you get married, especially in blended families, you may or may not actually want your spouse included in your plan. Maybe you both came in with sizable assets, and so you still just want everything to go to your children. You're not doing a joint plan. Your trust still then needs to identify you are intentionally not including that new spouse. Otherwise, they can legally, when you're gone, have a right to your assets. So, again, come and talk to us. The opposite is the question. Have you, since setting up your plan, had a separation where you and your spouse are no longer together? I talked to a woman a couple years ago who had had a plan. She'd been divorced for about 10 years, and still her trust identified her spouse as her power or her advocate, so her trustee. Her will or her, I apologize, healthcare directive and financial power of attorney still had her ex-spouse identified as her medical and financial power of attorney, which meant if she was rushed to the hospital, that person could still then go and make her medical decisions for her. He was also still a beneficiary in her trust. So if she had assets in that trust and passed before him, he still would have received those assets through that trust. So if you have gone through a divorce, if that person is no longer who you want to make your decisions, they are no longer who you want to benefit from your estate, you have to update it to remove that person out of there. Or legally, they still have control and they can still benefit from your assets. Now, one of the pieces also is, again, protecting against the remarriage component. Let's say it's your first marriage, you love the person, everything is great, everything is going well, but you pass away at any period of life. Remarriage is a concern. And so at that point, we're talking about, again, a trust that allows your half of the estate to be protected from change. That doesn't prevent the person that has been left behind from using your assets, but it does prevent them from giving those assets to somebody else that you do not know and would not want the money to go to. So if that is a concern, it is absolutely something to come and make sure you either already have in place or have added if it was not there originally. Now let's talk about beneficiaries. With beneficiaries, there's two things you might be protecting them from. Sometimes it's outside predators. This is a very common one. So when we're looking at a child inheriting, one of the things that you can set up is a protective trust that protects the inheritance from outside predators. What that means is when your child receives their inheritance and then, let's say, 5 years later goes through a divorce, that inheritance cannot be taken away in a divorce. What happens if they receive their inheritance, live a long, happy, healthy life with their spouse, but they predecease their spouse? And that spouse then remarries. Would you want that inheritance to go to that spouse and new family, or would you want to ensure that it stays in your bloodline and so goes ultimately to your grandchildren? You can provide for that. What happens if your child is in a horrific car accident? Insurance won't cover it all. It's an absolute fatality case that is going to go above and beyond what insurance will cover. The lawsuit and the debt that comes out of that cannot touch your child's inheritance. So it's acting as a safety net and a wall of protection around that inheritance. But there's a second category of who you might be protecting the inheritance from, and that is from your beneficiary themselves. So I know in some cases there are beneficiaries that should not be receiving an inheritance to them personally. By that, I mean they may need to receive an inheritance and you may still want them to receive that inheritance, but maybe they are not financially savvy. They spend more than they make. They're in debt constantly. You don't just want this inheritance to be blown. You want it protected from themselves. What if they have a drug or alcohol substance abuse issue? Again, you still want them to have this money as a resource, but you know putting it in their hands could lead to catastrophic results. You can set these trusts up in a way that puts someone else as a manager over that money. That way, the child, again, can still receive an inheritance, but doesn't have the risk of just blowing through it themselves if the concern is protecting them from themselves. The other group of people to protect from a beneficiary standpoint are those with special needs. One of the most common things we hear is, I can't leave my special needs child any inheritance because they will lose their government benefits. That is 100% true if it is done without protection. But with a special needs trust, you can leave them their inheritance with somebody else to oversee it so that they keep their benefits and their inheritance supplements what the government will not provide or cannot provide. So it's at that point the best of both worlds. Let me pause for a quick question. For an AB trust, does the couple have to have 50% in each of the trusts? Could they delegate it differently? So with an AB trust, it is 50% of community property on both sides, and then any separate property goes to that person's trust respectively. But if it's community property, it is then 50-50, and that is just California law at that point. Back to the special needs trust. If you have more questions, you'll see that there is a QR code on this slide that will actually bring you to a webinar that we did specifically on special needs. So if this is something that is more concerning for you directly, or you know somebody who has this issue that needs to be addressed, please send them there. Again, with special needs planning, you normally have somebody who is in a typically more vulnerable position, and in some cases has no ability to advocate for themselves. And so putting protections in place ensures that you are still advocating for them, even if you are gone. One of the most heartbreaking scenarios we dealt with was parents who had 3 kids, one with special needs. How they designated the money was not using a special needs trust. They just left the 1/3 to the eldest child with the intent that that eldest would take care of the youngest special needs sibling. That did not happen. The eldest, who I don't think at the time had any nefarious intent, bad will, bad intention, when he though ultimately received that money, he did keep it for himself. And so we got a call from the middle child desperately trying to figure out, how can we protect our youngest sibling? Can we force my eldest brother to use that money? And the answer was no. It was legally his, legally it paid to him, and there was nothing that we could do to force him to take care of the youngest. So again, special needs planning doesn't apply to everybody, but is an extremely important tool if you have any more questions on it. Is, do you need to update your people? So that can be your trustee, so who would administer and take care of everything when you're gone. Your financial power of attorney, who is going to be the person, if you're incapacitated, making sure everything financially stays on track. Your medical power of attorney, is it still the right person to be your medical advocate? And then, of course, your beneficiaries. So truly, as your life is shifting, as people have passed away, as they have moved, as relationships shift, as kids get older or grandkids come into the picture, are things still the same? Are they the right people that you named 20, 30 years ago as they would be today? If you have not seen us in the last 3 to 5 years to review this, now is very much the time to do so. And then, has your life gotten more, and maybe for better or worse, complicated? Do you have rental properties that need protection? Do you have grandchildren that you want to provide education funds to? Do you now have minor children that need additional protection? With minors, just because a child turns 18 doesn't necessarily mean that they should be handed an inheritance if you had, God forbid, passed away. Your minor's trust allows you to decide when that child would actually receive the inheritance directly. So again, as your life has shifted, has it gotten more complex? Do we need to do any kind of additional planning that goes with the trust that you had originally done? So now let's shift to legal changes. So your life, let's say you're all caught up on the life piece, everything is up to date, but how has the law impacted your plan? There have been a frightening number of legal changes over the last 3.5, 4 years. And so it is very important to make sure that you are keeping yourself and your documents up to date on these different changes. First and foremost is Proposition 19. So if you have not already heard about this, this is a proposition that very much impacted your residence and your properties being able to transfer to beneficiaries without reassessment for property taxes. The good news of this proposition is that if you are over 55 years old and you are planning to move within the state of California, you can move your tax bases up to 3 times in your lifetime, again, if you're over 55. The problem is, at the point you have passed away, there is almost no way for an inheritor, a beneficiary, to keep your property taxes what they currently are and not have them reassessed. In most cases, beneficiaries are having property taxes reassessed and brought to whatever the current level would be. The only exception to that rule is if you have a primary residence that transfers to a child who also then owns and claims it and lives in it as their primary residence indefinitely. If after 10 years they decide to turn that into a rental and Prop 19 is still in effect, the property would be reassessed as soon as it became a rental. So it is, again, very restrictive on what can transfer without that property tax reassessment. Now, if you are a parent of more than one child, you do still have options. If you have one child, your life, frankly, is easier because it's going to that kid. They get to decide what happens. It's really just at that point in their hands. But if you have more than one child, this proposition makes it almost impossible to keep your tax basis. And the reason is, in this example, let's say you have 3 children and you distribute your home after you're passed to all 3 kids. And after the distribution is made, one of them says, hey, brother, sister, I would love to own and live in it. Can I buy you guys out and this property be mine? And they say, sure, give us the cash. So child A buys out child B and C. Unfortunately, that is now a child to child transfer. And what that means is 2/3 of the property taxes are going to be reassessed. So the way around that would be that in your trust, you put what is called a right of first refusal. What that means is you can then, based on either who you think is most likely to want to own it or eldest to youngest or whatever order you say, you can say, child A, through my trust, you have the first right to buy out your siblings. That way it still qualifies as a parent to child transfer. And if they decide to take that opportunity and buy out their siblings and keep the whole property for themselves, they can at that point still keep your entire property tax basis as long as those other conditions are met. So if this is something you're concerned about, you need more information on, you want to know if it's applicable to you, again, come and talk to us. The other thing is that if you are planning to purchase a new property in California, come and talk to us about doing an LLC ahead of time. If you buy a property in an LLC, it can then allow you to transfer it to whomever after you pass and keep that low property tax basis. But it has to be done beforehand and it has to be done correctly. So again, if you're planning to purchase property, come and see us before you actually do. Now, another huge change is Medi-Cal planning and what is allowed or not allowed with long-term care costs. So Medi-Cal has drastically shifted in the last couple of years. Most people are still under the impression that if they have more than $2,000 in their property, they would never qualify for Medi-Cal. Well, it actually shifted back in 2022 to say if you had more than or under $130,000, you could actually qualify. Well, that shifted again at the beginning of this year. And they actually, Medi-Cal did away with asset disqualification rules. So in theory, that meant any person could qualify for Medi-Cal if that became necessary. The issue, though, is they are looking at people's incomes. So depending on your income level can make or break whether you qualify. But Medi-Cal is a program that anytime you have paid taxes, you are in theory paying into that Medi-Cal program. And so at the point that you need long-term care, which is an exorbitant cost anywhere in California, and frankly, at this point, probably anywhere in the country, At the point you need that kind of care, Medi-Cal is something that can then come in and either supplement the assets you have or the income you have, or if you don't have the income and you are in need of a full Medi-Cal plan, can actually pay for the entire amount of care that you would need. Medi-Cal qualification is very complicated, though. They are not designing the program to qualify people with the forms that they send. They're very much sending those forms with the idea that you will fill them out incorrectly and not qualify. We do have a team that is able to help you through those forms and work with a Medi-Cal specialist to ensure that you have the best chances of qualifying out the gate rather than hitting delays and roadblocks if it is not done correctly. So if you are in financial and physical need of additional assistance and programs, absolutely come and talk to us. Again, things have changed quite a bit, and so it is important to make sure that you are maximizing the options available and having them done correctly. Another big change was the Secure Act. So the Secure Act deals with retirement accounts, so IRAs, 401ks, those sort of plans. The Secure Act has drastically, again, impacted inheritance rules. So what it has said is that rather than when your child inherits your IRA or 401k, they have their lifetime to take the remaining money or just use required minimum distributions, they now only have 10 years to do so. So why is this important? What does this affect your estate planning for? If you have those protective lifetime trusts that I mentioned that can protect your children from either inside predators or outside predators, and you have retirement accounts, you need to come and talk to us to make sure that your trust is properly compliant with this new Secure Act language, or there can be significant tax consequences if it is not done correctly. That 10-year rule has a very strict penalty at the end. And if it is not all done correctly and in that 10 years, there is a tax on the entire remaining amount. So it is unfortunately a very large tax issue to be dealing with. The other thing, though, on a non-estate planning side, is if you are not already working with a qualified financial advisor and CPA, come and talk to us if you need referrals. There are different strategies you can do to make sure that you still get full benefits during your life, but that you're reducing tax liability for your children or whoever's inheriting when you are gone. These are things, again, that we want to help make sure the government isn't getting extra. They already have been taxing you during your life. They've likely already taxed this money. So we don't want them getting extra over what is legally required. Now, there are a few exceptions. So your spouse is still an exception, minor children, disabled children or beneficiaries. There are still, again, exceptions to this rule. But as a vast majority of inheritors, they now need to make sure they're compliant with that 10-year rule. Now, there are also a few new documents at Copenbarger. So what we are always seeking to do is ensure that we are providing any documentation that is going to be legally accepted to protect you and to protect your beneficiaries or your children at that point, your dependents. The first document that we now have is called a psychiatric healthcare directive. One of the things that we have been finding, unfortunately, is that for psychiatric health facilities where that is their focus, even though our healthcare directive addresses mental health concerns, they are not accepting the healthcare directive and are not at that point allowing those advocates to actually advocate for that person. They're requiring this separate psychiatric healthcare directive. So if you're concerned personally about any mental health issues, psychiatric health issues that could come up, this is something to have in place. If you have beneficiaries, dependents, children who have psychiatric health issues, this is 100% something to have in place. Because if or when somebody has a mental health crisis, that is not the time, again, that you want to be stuck going to court to have them either validate your current document or to create a new power. So this is not going to be universally used for every client that we have. This really is for mental health concerns specifically. But if that is a concern, this is now something that we can offer and use to help protect you or your loved ones. The next document that we now have is what is called a temporary guardianship. So, one of the things as life has changed is that people live all over the place and we still stay in very close contact with them. That is not the same as what was 10, 20, 30 years ago, where if somebody moved, for the most part, they weren't really somebody you looked at as a guardian of your child because they likely weren't someone you stayed in as close of contact with. Well, again, now that has shifted drastically. So, one of the things that we were seeing is that people were naming guardians of minor children that either didn't live in the state or, in a lot of cases, actually didn't even live in the country. And so the concern was becoming, well, what happens if I pass away and my guardian lives in India? How are they going to get to my child in a timely manner? Just the flight alone is going to take a long period of time, but that's without any other delays, preparation, or needs. And so the temporary guardian can be then appointed and used while that permanent guardian is getting to your child. So it's essentially saying who can take care of those kids on a temporary basis if needed. A lot of times the question is, well, why would I need a temporary guardian? If it's somebody I'd name temporarily, why wouldn't they be permanent? This we see a lot of times with grandparents. So your parents may be elderly and not somebody who is in a position to permanently take care of your child, but they would be somebody who, at least for a day or two or three, would be able to have custody of that child to make sure that they're protected and in a safe environment. So again, if this is a concern where either you know you're going to name people out of the area or you already have named people out of the area, come and talk to us about temporary guardianships. And then the next one is actually a medical power of attorney for minors. So this is something that you set up on your minor's behalf. And it is something that says, if I can't be there to make my child's medical decisions, who can be? So this can be if you're traveling, you're going to be out of the country, you're leaving your child with your sibling, they're going to have custody of them for a week. Well, what happens if, God forbid, there's a medical emergency, crisis, or something happens in that week period? And your child, you're not there to tell the doctor who can make the decision. Your child doesn't have the legal ability to do so. This document allows that person to advocate for your child. What happens if you're going through your own illness? So, unfortunately, there's some illnesses that just absolutely wipe us out, whether we want it to or not. And you cannot physically go to the doctor. You're not really even in a state mentally that you can make those decisions for your child. And so, this also allows you to put people in place for that. So, again, protection if or when the time arises. So I know that was a lot of information in a relatively short amount of time. What I will very much say is, if again, you have not seen us in the last 3 to 5 years, now is the time to come and talk to us. It is extremely important to ensure that those documents are kept up to date to ensure that you, your family, and your assets are fully protected in a way that is needed for you. Every single trust that we do is customized. And so, again, we want to make sure that what matters most to you is provided for in those documents. Now, if you have not worked with us, or maybe you have, but it's been a long time and you're questioning why should we stick with Copenbarger, I'm going to just go over this quickly. One of the things that sets us apart and will continue to do so is the education that we provide our clients. One of the things I hate hearing is from people who've worked with other attorneys where they say, I haven't heard from my attorney since I set my documents up 10, 20, 30 years ago. I don't even know if my attorney is still practicing, if they're even still alive. I don't know what my trust actually says. I feel like it wasn't ever fully explained. Those are things that Copenbarger clients will not say. We are reaching out to our clients all year long. We are doing these education events all year long, and we are ensuring that your protection is understood by you. You are the ones in the driver's seat, and that should 100% be the situation with your estate planning attorney. So if, again, you haven't worked with us or you're wondering why to stay with us, that on its own is enough to set us apart from many, many lawyers in this area. The other thing, though, is we very much continue educating ourselves. So as these laws change, we educate ourselves and then present it to you. That way, rather than you having to try to keep up with what's going on and what's happening, we're continuing again to educate ourselves. So one of the questions is, what is the range of cost a typical 5-year spring cleaning update and checkup? So a couple things with this. If you are an Access member, you are entitled, so that's a membership through Copenbarger, you are entitled to 2 hours of attorney time every Access year. So if you have not already used that, the cost to come in for the review would be free. If you have not seen us this year yet, and this is your first education event, you would actually also be entitled to a free consultation. So if this is going to be your first meeting of the year, let us know that. And then that, again, consultation is complimentary. As far as the cost, if there are any updates, that is very dependent on the update. So that can range from a couple $100s to a couple thousand, depending how complex and how involved the process and update ends up being. But what I will say is at the end of your consultation, in most situations, you'll have a precise amount that shows what the update would cost so that you can decide, is that something that you want to do? So after this, you will be receiving an automated phone call asking if you are interested in setting up that appointment. So if you are, I very much encourage you to take advantage of it. We also have a survey link in the chat. So if you are willing to answer that, we would very much appreciate it. That lets us know how this was. Was this helpful for you? Was this information that was applicable? Because we very much want these to be helpful to our clients. But again, if you have any other questions, please let us know. Call us at any time, visit our website, email us, however you want to get in touch. We're pretty accessible. But we look forward to working with you and hope you guys have a great rest of the day.